There's now a third case that we're involved with since last January. This time, we are representing 52 legislators in a divorce case involving a lesbian marriage. And the particular issue in the case is custody because one of the women had a child by artificial insemination. Now, here's the problem. Tennessee's family laws were enacted on the assumption that marriage involved a mother and a father, and on the assumption that motherhood and fatherhood were rooted in the individual's sex. A man would never be a mother would never be a man. And rooted in the assumption that there was a biological connection, that the father is the person who's fertilized the egg, the mother is the person whose egg was fertilized. And by law, only a parent, a term tied really to sex and procreation other than in adoption situations, only parents have custody rights. So in the Knoxville case, one of the women is clearly not the biological parent. So how does she establish a legal right to custody to what she calls her child? Now she's using a statute in the state that says this: a child born to a married woman as a result of artificial insemination with consent of the married woman's husband is deemed to be the legitimate child of the husband and wife. Now, we already have a statute on the books because there's been a lot of controversy about this bill. There's another statute that says that when a man and a woman are married, we just presume that the child is that of the husband and wife. We don't ask questions. If your child looks completely different from your wife, we don't ask why. That statute's still on the books, okay? But this one, I don't know why it was passed. It was passed at the same time. The problem, obviously, for these two women is that the non-biological person is not the married woman's husband. She's the married woman's wife. So she is arguing that the court, because of Obergefell, must now reinterpret the word husband in that statute and substitute the word spouse. Okay? Now, the worst part about all of this is that our state attorney general, and we'll talk more about his office later in the evening, has filed a brief and says, they're right, this statute is unconstitutional anymore, but Your Honor, you have the authority to rewrite the statute. That's astounding to me. And so he's saying you just block out the word, as you see there on the screen, husband, and you just substitute, Your Honor, the word spouse. And where it says husband and wife, just rewrite that too and put in the words the two spouses. That's why our Attorney General has argued to the court. In order to make the statute constitutional, you just rewrite it. The problem is judges do not have the authority to rewrite laws. You see why I say we have a crisis of authority. But that's what the Attorney General says that we should do. But we have a problem. The Attorney General has argued for an interpretation of the statute that now reads like this: a child born to a married spouse as a result of artificial insemination with the consent of the married woman's spouse is deemed to be the legitimate child of the two spouses. Okay, that's what the Attorney General says. Who is the married person, the married woman in that relationship? Can you spot her? So the Attorney General is arguing that the court should rewrite the statute in a way that makes the statute now, as rewritten, unconstitutional when applied to two men. Isn't that great? That's what happens when judges, urged by our Attorney General, start trying to rewrite statutes. So we have a bill that would simply repeal that statute. You may have seen a huge flap and controversy over that in the last few weeks. Some silly newspaper reporter wrote that it would make children by insemination illegitimate. Didn't bother to call the sponsors. That is not true, if that's what you hear. But in other words, this statute is so messed up, it is not fixable by a court, and it's not supposed to be fixed by courts anyway. So we're going to repeal it.